Hey, welcome back to the CCW Safe Podcast. I'm Mike Darter in Oklahoma City with my Thunder sweatshirt on. We're the only company that is in Thunder Valley.
All right, all right. I'm Stan Campbell here again with my partner in crime, Michael Darter. And we got a great guest today, don't we, Mike?
We got Don.
The Don, Don West,
Thanks,
National
guys.
Trial Counsel
Good
for
to be here
CCW
in
Safe.
Oklahoma City again.
That's
Great
right.
to have you here, man. We love having you up here. We're going to have a great podcast today. We're going to talk about some of the things that you've worked on in cases that have become either problematic or have brought problems, or things that you've seen. We've got plenty of them on our site.
We really do. And then he's also going to give us some insight to, he kind of followed the Amber Guyger case, the Dallas officer that was involved in that shooting, real controversial shooting. So Don's going to give us some insight there. And we're going to also learn about what he and Sean Vincent got coming up.
Sure.
Cool.
Yeah.
Sure.
So we got a lot going on today. And but before we start, Michael makes fun of me sometimes because not only am I I can be a dangerous guy, I can be a tough guy, but I like to get my nails shined. And I found this girl, Hawaiian Nails. Shout out to Hawaiian V and Hawaiian Nails up off Memorial May, and she really got my shine to match the shine of my head. So thank you very much, V. Michael makes fun of me, but I like my nails to look good.
And that's how we're starting off today.
Yeah, we are.
Okay.
I feel good about that.
Well, I'll also say we've got our CCW Safe tumblers here, which we're going to give one of these away. So we're just going to say the best comment, and it can be in an email form. It can be on Instagram, YouTube, Facebook, whatever. We're going to check the comments, and we're going to pick one. We'll talk about it next week.
Yeah.
And we're going to send you out a Polar Camel CCW Safe tumbler,
That's right. I love these.
laser engraved. Yeah, these are nice.
Yeah, I represent every week. This is Michael's first time joining in, but I love this thing.
Last week you killed it with it, man. You got all the ratings
Shut up.
with your shiny nails.
That's right.
So let's get into so what's going on new with you, Don?
Well, as you guys know, I spent some time with Andrew Branca.
Yep.
Working on some stuff out at SHOT. And we're looking forward to how that's going to be sort of packaged and put out. And I think it'll be some good material, some good talking points,
Cool.
and a good opportunity to introduce some of our members to Andrew.
That's right.
And vice versa. I think we work well together. We're complementary in our mission, and we're glad to see him partnering up with us.
Yeah, it's not too often that we find an attorney in our industry that is also aligned with de-escalation and avoidance. And a lot of this stuff, and we send a lot of our members Andrew Branca's way, and we do some soft partnerships with his books and different material that he has as well. But he is one that we actually do endorse because he's aligned with our core values and the things that we actually do, and how Mike and I present information to our members on how to be their own risk managers and how to avoid some of these deadly force incidents. Always be ready for the ambush, but you have to be ready to walk away as well.
Yep.
Yep. So let's get right into it, Don. The Amber Guyger case out of Dallas, you followed that pretty closely, correct?
Yeah, I did. The incident was in the late summer, early fall of 2018, and then the trial was about a year later.
Mm-hmm.
It was, by all accounts, just a tragedy.
Yes.
Amber Guyger had worked that day as a Dallas police officer. She had gone home at the end of a long shift. She went into what she believed to be her apartment and encountered a stranger there that she perceived to be an intruder.
Mm-hmm.
One thing led to another, and she fired 2 shots, one of which turned out to be a fatal shot. And, of course, where the tragedy began and then compounded ultimately into into the death of a fellow named Botham Jean, and ultimately her prosecution was that she went into the wrong apartment. She went into a place thinking it was hers, and in fact it turned out to be Mr. Jean's apartment. So she made a critical mistake right from the very beginning. She was prosecuted. She was originally, I think, charged with manslaughter, and then the charges were increased by the grand jury to murder. She went to trial on a murder charge. A lot of people thought that maybe she would be, because she's a pretty sympathetic person. She's a career police officer, and by all accounts, a good person and a capable police officer. A lot of people thought maybe the jury would convict her, if not acquit her, convict her of a lesser charge, but in fact, the jury verdict was for murder.
Now, because you watched the case, and and as a police officer, we always think about, going into these encounters, knowing that a split-second decision could cost you either your life or the failure to do so, or send you to jail as well. So we keep that in the back of our minds. But never have I thought about, coming home and possibly, dealing with an intruder or entering the wrong home. So, this case actually stuck out to, a lot of us. And, Don, in particularly, you found this a very interesting case to start off with. But as you followed it, because I think you also tried to get down and sit inside the courthouse as
I did.
well.
I was in Dallas at the time of the trial, and I actually went to the courthouse, got inside, was never actually able to get inside the courtroom because there's just no seats left.
Yes.
It turned out to be quite a small courtroom, and with family and press and other interested people that had a priority, there just weren't enough seats. So that day I was outside among those in my position that couldn't get in either, kind of waiting for to see what was going on. And interestingly, you could actually hear what was going on or live stream what was going on outside the courtroom. So
Really?
you had an idea of what was going on,
Yes.
but I was 15 feet away.
So if you had to defend her or just kind of looking outside, looking in, what are the problems that her defense attorneys had with her case?
We know that from having been involved in self-defense cases, basically our whole professional lives, that many times big cases turn on how little aspects or small facts are viewed. In this case, there were some really huge facts that were clearly established, no doubt about it. Then there were some other things that were in dispute. And how that all laid out ultimately, I think, gave the prosecutor an effective argument on this notion of reasonableness.
Yes.
So we have Amber Guyger going to the wrong place. The prosecutor pointed out that she should have known that she was not in her place. A little fact that there was a different floor mat in front of the door. She should have known that wasn't her floor mat. It was a different floor. Now all these apartments sort of look the same. Also, she was able to gain entry to the apartment without using her key. So the door had been unlatched in some way that this wasn't a situation where her key worked by accident.
Gotcha.
She actually sort of pushed the door open, realized at that point that there was something that had gone on. She still didn't realize that it was not her apartment.
Yes.
She goes in, and then the prosecutor could argue, well, the furniture wasn't the same configuration. And
Yes.
more indications that she should have known she was in the wrong place. And then, of course, the question of what happened actually inside the apartment. The testimony, as I recall, was that Mr. Jean was there, kind of just hanging out in his own house, watching TV, had just gotten a bowl of ice cream, was sitting down, maybe there was some music on, and was startled by Amber Guyger being in his place. So he kind of gets up, and her testimony was, as I recall, that he came toward her. I think she said she told him to show his hands or something, but in his state, he came toward her, and that's when she decided to discharge the firearm. As I mentioned earlier, she fired twice. One shot apparently missed altogether, and the other shot him in the chest area. It turned out to be fatal.
Okay.
You
Now-
know, I can say because I was in an apartment for a short time, and that happened to me twice.
Really?
Yeah, because it sounded like in that case she thought she had parked on one
her
level,
floor.
and that's the way this apartment was that I lived in for a short time. They had parking garage, and you'd park on your level and walk in. And twice I walked to the apartment underneath me, tried to put in my key, couldn't get it in, looked at the door, and I thought, oh, I'm at the wrong floor.
Yeah.
So that's happened to me before.
Yeah.
The other thing that I saw in this case, I think she had worked a 14-hour shift.
And she was in full uniform. She still had her equipment belt on
Yep.
and radio. And the prosecutor pointed out that the police department itself was just a few blocks away.
Yeah.
And the prosecutor ultimately exploited the idea of, with her training, with her knowledge of how these things can go bad, especially if there is in fact an intruder, why did she exercise the judgment that she did, claiming that her decision to go in and confront whatever she believed to be inside was a bad decision. It was unreasonable when she could have simply phoned for radioed for backup.
Wasn't the thing that hung her was that they asked her what her intent was when she went in, and she said her intent was to kill the guy?
You know, that's a brilliant point, Justin. And as I commented before, sometimes big cases can turn on little facts or interpretations of little facts. She was on the stand, and the prosecutor was questioning her about what happened at the time that she shot him, and basically just said, were you trying to kill him? Did you intend to kill him? And she said yes. And I thought that was a critical mistake. I still think it was a mistake on her part, in that she was on the stand, which is a really difficult thing to do, to testify in open court, subject to being cross-examined. Just the whole notion, being on television, all that stuff is disconcerting. I do not believe, just on the other things I know about the case, that that was an accurate statement about what actually happened. But that's what she said. And then it's almost impossible to come back from that. The notion that she was trying to kill him contradicts all of her training. They aren't trained to kill somebody. Killing somebody may be the consequence of the use of lethal force, but it's not the objective.
Correct.
Hardly ever.
That's what I was going to say. That's a big point for law enforcement officers or anybody concealed carrying. If you're in a shooting, you never shoot to kill. You always shoot to negate the threat. And that's the way we were trained.
Correct.
And therefore, that's the intent of any lethal action, is to negate the threat to you. But one of the points I was going to make, working a 14-hour shift, and I don't know what time that was, but I worked, I worked midnights for quite a bit of my career, which was 9 at night to 7 in the morning. I worked second shift, which was 4 to 2, 4 in the afternoon to 2 in the morning. And then I worked some days. Third shift was always the worst.
It really was.
When you get off of a late third shift and you get a DUI, late, or you get on something where you have to be on, you have to take somebody to the hospital and you're stuck there. Coming home, I remember coming home times where I was just totally out of it.
Yeah.
So I guess what I'm saying is I can see, I can kind of see what happened or what actually led up to this with somebody getting off a 14-hour shift, being tired, not alert to anything, coming home, parking on the wrong deal, and getting there. But that's kind of where it stops for me.
Yeah.
Because if you got into a situation where a door was open, number one, you push. If I go home and I push a door open, and especially if I hear somebody inside, I'm probably going to immediately call 911.
Correct.
Post at that door.
Yeah.
And try to wait until somebody gets there.
Well, there's a couple of other things I think that are relevant to this case and that discussion. First of all, she would have known, since she lived alone, that no one else was home. So she wasn't didn't need to go in to protect someone
anyone
else.
yeah.
Yes.
Apparently, she had a dog, and that she had boarded the dog, or
Yeah, that's right. That's right.
because she had been told that at some point in time, I never gathered or never figured out when that was, maintenance may be coming in. So the dog was boarded up. So the prosecutor really made a lot of effort to point out all these things that happened that made her decision to go in and confront whatever it was that was in her apartment on her own unreasonable. Essentially, creating the opportunity for a confrontation where she had other viable options, just to wait outside, as Mike said, just to call 911. She could radio. There were people within seconds,
Blocks,
or
yep.
if not minutes.
Yeah. And you know, when I watched it too, like Mike said, and we talk about this all the time with our concealed carriers, it really is important, no matter who you are, if you're a police officer, which police officers should do it more often, but citizens should follow the same. If you find yourself in an incident or an encounter that is not an ambush where you don't have to act immediately to a threat, you always have to call for backup. I always say this for citizens as well. So backup is 911. You know, I was surprised that she didn't do that, like Mike brought attention to. But it's so important as a citizen, get help on the way. You know, don't enter and clear a house if you don't have to. Make sure that, you know, if you know that, you know, you're safe outside, you don't know how many people could have been in there. It could have been more than one person. And you know, they could have actually, you know, she could have been overcome. And, you know, so it's really important just to think about your safety overall. And I know there's other circumstances with this particular case, but think about all cases in which, you know, cover your friend. You know, cover is your friend. That means behind a wall, behind a car, whatever the case may be. That keeps you from having to react, you know, haphazardly or too early, you know, because that becomes a problem sometimes, and it comes up in court often. Or, you know, it gives you a chance to think as well, you know, getting your thoughts together so that you don't move too quick and react like you should not. You know, I was thinking about that case too, because in the internet it was a buzz, Don, and I want to find out, do you feel that race played anything, or I mean, was it a factor in maybe them deciding to go with murder?
I don't think so.
Okay.
I think there were efforts made by representatives of Mr. Bothenjean's family to introduce the question of race in this. I don't think, though, that anyone believed that Ms. Geiger was motivated by some sort of racial prejudice.
Yes.
I don't know that she even knew the race of the individual when she fired the shot. The prosecutor attempted to make something out of that during the trial, though. There were some comments made on, I don't know if it was an email or something to do with a Martin Luther King parade or some event, and really tried hard to make it look like she could have some, you know, prejudiced aspect. But I thought that completely was backfired, because she was well respected, well liked by members of the Fourth Force of both races. She had a best friend that was a police officer, a very compelling, powerful individual who came in and spoke on her behalf that was African American. And I think that while there may have early on been some attempts to introduce race into it, I have no reason to think whatsoever that the jury seriously considered that.
Okay.
And there wasn't anything else, right? I thought I remember something. There wasn't any other history between them as neighbors, right?
No, I think that Ms. Geiger had only lived there 2 or 3 months, maybe.
Okay.
She was pretty new in the building, and I don't believe they had ever met.
Yeah.
Certainly no history of any conflict or bad blood or anything. That was just she just went to the wrong
yeah.
Yeah, it was
part.
kind of strange because, like, you know, they even brought in the fact that, because, I mean, before they gather facts, you know, it goes crazy on the internet. And, you know, they talked about the possibility of them having an intimate relationship. Like it was like
I think that may have
like
been
it
what
was
I
an
remember.
ex-boyfriend, or, you know, she did this, you know, in response to that.
Well, there was an aspect, not as between Ms. Geiger and Mr. Jean, but there was a little bit of sleaze, if you will, introduced into it because of her former partner. I think he and she had been lovers at some point. They still texted frequently. Justin, you may know more of those actual details.
She was texting him when she was walking into the building.
Yeah, it was ongoing, and they were using
okay.
that as part of the distraction and failure to focus on what was.
Yeah, so
right.
she was texting him, as far as I understand it from when I followed the case.
And maybe even after, maybe even shortly after. Which reminds me, some points that the prosecutor made that are good lessons for everyone to know that's involved in a potentially lethal self-defense scenario is that her after-incident conduct was also examined under the microscope, and she was criticized for not rendering aid quickly enough or enough aid, and they even went so far as to say who had blood on their clothes and who didn't, because the responding officers clearly rendered more aid. Now, I think she did render aid. I don't think she was necessarily, I think she was confused. She still didn't know where she was. She was having a detailed, lengthy conversation with dispatch trying to figure out what was going on. And she did talk about losing her job repeatedly, and that was exploited as if her priorities were clearly in the wrong place.
I mean, my what I took from the text and stuff that I saw, it looked like somebody knew they made a mistake. Their life was changed, and now they're dealing with this.
Yeah, and that's
like
why
this overwhelming thing. Like, I just really screwed up.
And one of the things I was going to say, when you're in a shooting, I mean, there are, just a rush of not only emotions but also the physiological aspects we've talked about, and it really is. It really is. Coming from somebody who's actually been in one, it's very almost. It's confusing. It's almost like an out-of-body experience. It's almost like you're looking at and it's hard to explain. But I think what I'm trying to say is, if you're involved in a shooting, things are not going to be right in your mind.
Yeah.
Things are not going to be right in your mind. You're not going to know, what. You're not going to be able to recall certain things that led up to that at that time. And that's one thing we talked about with Alexis Artwall, which she's got a new book out. We're going to be talking to her soon. But she talked about, one of the biggest things with law enforcement is the intense second guessing and, knowing when not to do that, because a lot of times you don't know what happened, and it's human nature to justify yourself, so you fill in with what you think happened to justify yourself, and which can ultimately be damning in the long run too, especially if it's something that is against forensic evidence.
Absolutely.
And there's
one thing that I found really interesting in the case was the Texas Rangers got on the representative. I guess he was a lead investigator for the Texas Rangers. Got on, and they found her basically justified. Like he testified that essentially they didn't think she did anything wrong. Like, based on.
Well, and that was probably based on the perception, her perception of what.
That was my understanding.
Yeah,
like
let me qualify that, though, because you may have a clearer recollection of what actually played out than I did. I'm aware of that determination by the use of force expert, in a sense, but I believe that opinion never went before the jury.
The reason it sticks in my mind is because after he testified, there was a big uproar online, and there was a lot of people in the places I read, the forums and groups and things, that were really disappointed in the Texas Rangers as a entity, because they were always viewed, at least from the outside, people in Texas seem to have a real high regard for the Texas Rangers, because they're generally the ones that come in if there's a weird case or there's any appearance of impropriety. The Rangers come in and they're kind of viewed as straight and narrow, and they'll get to the truth. And so when that happened, that's what sticks in my mind about it. And his testimony's online. I remember watching it on video, but word for word, it's available out there. But
See,
that was just
my
one thing
confusion was I thought that was in a motion in limine that would have been outside the presence of the jury, where the judge heard all that testimony, as did anybody else that was watching the live stream.
I don't know if the jury heard it then.
And then the judge
possible
ruled
they
that it
didn't.
wasn't admissible.
It's possible.
I don't know that for a fact. I know that process or that scenario happens frequently.
Okay.
We've had other cases. We were involved in cases where we've hired use of force experts who were prepared to offer an opinion on the ultimate issue, but then the testimony was challenged. The vehicle is a motion in limine, just to limit testimony. The judge then often hears that through a proffer, basically hears what the testimony would be that the jury's going to hear, and then rules on its admissibility. That's pretty controversial. Lots of times judges will let in some of the evidence, rarely all of it, because it gets to the ultimate opinion about the case, and oftentimes not only will drastically limit the testimony, but will even exclude the witness. So I apologize. I should know the answer to that about whether it was before the jury or not, but I suspect, knowing as this thing
Do
went,
you have
that
an
it
opinion as to
wasn't.
whether it was reasonable for Amber Guyger to have believed she was in her apartment when she encountered the complaining witness?
Yes, I do.
And what is that opinion?
That she believed that there was a burglar in her apartment.
And that it was reasonable?
Yes.
And do you have an opinion as to whether it was reasonable for Amber Guyger to perceive, based on the facts and circumstances, that from her standpoint, that the complaining witness was an intruder in her apartment?
Yes, sir.
And what is your opinion?
That it was a reasonable perception.
And do you have an opinion as to whether it was reasonable based on the facts and circumstances from an ordinary, prudent person in Amber Guyger's position for her to perceive that Botham Jean was a deadly threat?
Yes, sir.
Yeah, and I think comes down to the perception at that time, which is common. I mean, you see common in shootings where people would say, well, how could that be? But as detectives look at it as the perception at that time,
Correct.
From that person.
It would be reasonable.
Don was right. The jury was not present when that was said.
Yeah.
So that was. He
So-
told the judge that, and then I don't know. I don't think the judge looked that in. I can look, but he said that. Let's see. Stunning pronouncement by Texas Ranger David Armstrong, lead homicide investigator on the high-profile case, came while he was under cross-examination by an attorney for fired police officer Amber Guyger, but not while the jury was present in the courtroom.
Yeah, and I think ultimately that testimony was not presented before the jury. You know, Amber Guyger had good lawyers. They were experienced lawyers. We can question how is it possible that she could say, yes, I intended to kill him. If she had good lawyers, that certainly would have anticipated something around there. But that's just the way trials go. There could have been lots of anticipation and preparation, or they could have just missed that specific issue. I'm giving her the benefit of the doubt because I just don't believe in a calm setting that she would have answered that way. She may have, in fact, said that earlier and was stuck with it. Don't know that either. But in talking about those kinds of things that could make a difference in the whole case, that could have made a difference. It certainly could have made a difference between murder and maybe manslaughter in the jury's decision. And the testimony there that was proffered from the Texas Ranger may very well have changed the outcome of the entire case if the jury believed him, thought he in fact was expert more than they were. That's sort of the test. You know, is it really a subject for which an expert's testimony is required? Find him qualified as an expert, believe him, could very well have, in a sense, deferred to that final conclusion.
Well, this is a case that is, and another thing I was going to bring up earlier, we've seen this in multiple other cases where people are at the wrong residence, whether it be, but normally it's not the either concealed carrier or the person with in defense is at home and has somebody else there. But I've seen this multiple times as a police officer where people come home drunk to the wrong house.
Yeah.
bam, bam, banging on the door trying to get in. And we've
Yeah.
seen it in some of the cases, you know.
That you guys worked up.
That's
they
right.
worked up
Sean
and
and I have talked about some cases.
And we had the
past.
one guy who called in, who sent the email in that because of the Ted Wafer case, he didn't react.
That's right.
He stayed calm.
Stayed
he stayed
inside.
Stayed inside.
And I think it wasn't it. I mean, he lived way out somewhere, and it was like a long period of time before law enforcement,
Right.
like 20
was.
minutes
Right.
or something.
Yeah, because
30
I mean,
minutes.
that possible intruder not only banged on the front door, he went around to the back door as well.
Yeah, trying to get in.
So the member did a great job of de-escalating and holding his.
And he was looking at him
he
through the
was.
window, which
Yeah.
that's something different. You know, usually if you have somebody come home drunk, banging on the door,
Yeah.
once they find out they're at the wrong house. then
Correct.
they can
Yeah,
get to
that
us
guy was
unless
kinda
they're
weird.
But that had some different aspects to it.
Circumstances,
But
And anybody could find themselves in that situation as a homeowner. Just some weird thing happens, and some drunk guy, crazy guy, lost guy, Uber drops him off at the wrong place.
that's happened before.
Yeah.
That's
So
happened before.
Sean and I are going to explore several cases, variations of that scenario. We've been working on some articles and podcasts. So we're going to focus on some of the aspects of that with real-world reported cases.
Awesome.
Yeah.
And try to identify the difference between those for which the shooting was considered justified and others where the individual got charged.
Nice.
Not necessarily convicted yet, but charged anyway from those that didn't.
Yeah.
And then there's a couple of the ones we talk about where the cases aren't finished in the system yet because
Yeah.
that can take years, where we think that there were some critical mistakes in judgment.
Well, the good thing about
unfortunately.
that, and if you guys haven't, make sure you check our news section of ccwsafe.com and the archives of their content. Their articles are great. You have a lot of lesson learned, from these articles, and going into the next step of not just presenting cases in which the victim shooter went to jail. Now you're going to be introducing cases in which it was a successful outcome as well. So
Success, of course.
Success as in
Success meaning that you survived the first fight.
correct.
Now, when you shoot somebody through a locked door, that's a little
Yeah,
harder
totally
to
different.
justify.
Correct.
But you survived that first fight, meaning that you are in fact attacked, or clearly there is a risk of this attack that would cause severe bodily harm or death, and you make it through that because you're not the one who died.
That's
and
correct.
then the second part of that process, we've called it the next fight.
Yes.
And other things where you're now facing investigation. Anytime a shot is fired, police are going to come. I
Yes.
just have never seen a case where they didn't bother if a shot was fired. Now, somebody displays a gun and nobody else is complaining.
Yeah.
The so-called victim isn't calling in. Not all of those result in a formal investigation, but I've never seen a case where a shot was fired.
shots fired.
The police didn't respond.
We were talking earlier, something I'd like to get Don's input on was about how something early in the case, a statement usually, like for example, Stephen Maddox talked for 12 hours without counsel.
Correct.
And then the defense had to go back and kind of overcome some of those statements that he made. Basically it made the case harder.
Yes.
Like if there were other examples, or if you want to go into detail on the Maddox example, like what are some things you've seen in your experience that people do that make it harder for them down the line in their defense? Whether that's statements, actions, choices, whatever that is. Is there anything you can speak to on that?
Yeah, I can talk about all of that sort of in categories. What you're talking about is something that a specific individual did within the context of their own case that they thought was going to be helpful, which in fact turned out to create challenges for their counsel. The 30,000-foot view of lethal self-defense cases is, I think, the most challenging are, all other things considered. And let me also say, we're talking about legitimate uses of deadly force. We're talking about innocent guy defenses where they have been attacked by someone, reasonably perceived all of that, used deadly force, and are now facing the prospects of being in the criminal justice system. Well, so from that viewpoint, I think the hardest cases are when someone shoots and kills someone that is considered to be an unarmed attacker. So you've got that disparity of force, this disproportion of bringing a gun to a fist fight.
Correct.
So prosecutors immediately look more carefully at those than they would if it was clear both people had weapons, all other things being considered. So that becomes complicated because the size, the capacity, the physical abilities, the age, all of that leading up to it and being evaluated during the event itself is critically important. I represent a number of individuals who shot and killed people that were unarmed because they legitimately believed that if they didn't use lethal force, that they would be seriously harmed or killed. And well, I can tell you that juries in the right case also agree, that there are circumstances where the use of lethal force against an unarmed attacker is lawful. So I know that legally is correct, and we also know that it can be attractive to jurors in the right case. Typically, what that would mean, I think, to the defender is you really want to be careful. You really want to know who you're dealing with. You want to do everything you can to buy yourself enough time that you have the opportunity to assess what this person's intent is and what their capabilities are. You don't just pull your gun out and shoot somebody because they raised their hand at you or because they're pissed. People who use the gun too quickly, that use it to win an argument, are the ones that go to jail. First and foremost. So that's an example from the big picture. Your point about statements, I think, may be the next big thing. We suggest that if you are involved in a lethal self-defense incident, especially, that when the police arrive, that you, of course, identify yourself, you explain very, very briefly that you were attacked, that you had to use force to defend yourself, and very little more. You're cooperative, but you don't put yourself in the position of giving a full debriefing, a detailed recorded interview at that point for lots of reasons. One of them is because of the trauma that you've just experienced, and we know from Mike's comments, Stan's comments, and other experts like Dr. Artwall that people just aren't very good at being accurate, and what they may say immediately following an incident isn't necessarily going to be reliable. And I can tell you the worst thing a lawyer can have to deal with is a statement that the prosecutor offers in the trial a year and a half later that is inconsistent with the testimony that your client is giving now, or inconsistent with some physical evidence that they didn't know about then. So I think that's good, reliable advice. You have to be calm enough and cool enough and collected enough to know how much to say and when to stop. The easy thing is you want to be cooperative, but you don't want to give your formal interview then. The second reason, not only because you aren't going to necessarily be very good at it, is you don't have a lawyer at that point, and you really don't want to put yourself in the middle of a criminal investigation without having the benefit of counsel. No police officer would do that. So another thing I think that's a big challenge in innocent guy or good guy self-defense shootings that makes the case difficult, that may not be under anyone's control, is the lack of forensic evidence. You know, a lot of people think that the absence of evidence is evidence. Sometimes it is, but not what most people think. For example, if somebody says he touched the gun and fingerprint analysts were not able to get any prints from the gun, they think he must be lying. Because there were no prints on the gun, but anybody who's worked a case knows there's a much greater chance there won't be prints even if they touch it than there is that you can connect the two. Just as the kinds of forensic evidence, like fingerprint evidence, DNA evidence, we now know that practically everything is recorded by somebody somewhere, whether it's a Ring doorbell or surveillance cameras and such. Getting that before it's destroyed, or identifying it before, while people may be able to hold on to it, knowing that it's relevant. So one of the things that we suggest people do is if they know there's evidence out there that the police haven't collected, maybe point that out too. If you were at a scene and you saw somebody run that way, you might want to simply say that the guy who attacked me ran off that way.
There's something that I think we should mention for what our service is too, is, and it's been demonstrated in several cases where we actually send an investigator boots on the ground almost always within 24 hours. And part of his job is to get out there and find those videos and that evidence and those witnesses before they disappear and things like that.
Absolutely.
So I think that's a huge thing that I want most people to know about what we do, is you can't put too much emphasis on the fact that you've got somebody there working for you within 24 hours, securing things that could make all the difference in your case, like you say, 18 months later.
Yeah, because that's the to think that the police are going to get all the evidence, it's just not going to happen all the time.
No.
Well, we had a case actually where we weren't sure if the police collected all of the evidence or photographed some critical locations where this thing unfolded. Got a lawyer and the investigator you were talking about on the scene the next day.
Yes.
And actually talked with the police to be sure they had documented that. And they assured us that it had been, and we accepted that. But we were fully prepared to take those next steps to be sure that that evidence was documented before it rained and
Yes.
before a year passed and before all of a sudden it was a he said, she said. I can tell you, having tried a lot of cases, especially when the attacker is unarmed, that juries, judges, prosecutors, police are a little suspicious of that. You know, they're a little suspicious of why a guy had to kill somebody that wasn't armed. So the more forensic evidence, the more eyewitness testimony, but frankly, that's not all that reliable typically. The more forensic evidence you have to prove the way that you said it unfolded, I think is critically important, not to get arrested perhaps, not to get prosecuted, ultimately to get acquitted. Now, that sounds a little backwards because the prosecutor has the burden of proof.
Correct.
In every self-defense case, after some evidence of self-defense is offered, the prosecutor has to prove it wasn't self-defense. But I absolutely guarantee you, if you have evidence to show it was self-defense, you want to put that in the record. You want your evidence to be as strong and as compelling as possible that just makes that job harder for the prosecutor to disprove. And if you have medical examiner testimony that corroborates your version of what happened, if you have photographs of your own injuries that shows that, yes, you were physically attacked,
Yes.
This guy meant business and was physically able to kill you before you acted, all of that stuff is what makes the biggest difference at the end.
And that's a good point we've talked about before too. Don't let anybody clean you up
That's right.
until it's documented. If somebody asks you if you're involved in something and you have injuries and they ask you if you want to go to the hospital, go to the hospital.
Yeah, but
Make sure everything
but make
gets
sure before they
documented.
clean you up, you get some pictures and document. You know, and also on to piggyback Justin's thought, you know, we put a lot. I think it was about a year that we put in really planning how to really make this the best model in the industry. And not to say that our competitors and those in the industry won't do what they say they're going to do. They absolutely will. But the thing about us, you know, when we decided to lean on our experience, which was, you know, number one for us, you know, over 75 years of collective law enforcement experience, and then, you know, reaching out and making sure that we get the top lawyers also who have over 35 years and work in self-defense cases. We knew that there was another element that we wanted to push forward, and that was the boots on the ground element. Because as police officers involved in shootings or shooting incidents, me mostly supervising, Michael actually being in one, if you don't get that boots on the ground, you know, the people there, those investigators, you know, seeking out that evidence, you know, it kind of starts going backwards, where Don was talking about the absence of evidence. But to my point, you know, when we have our critical response coordinators and other investigators, homicide guys that's working on your behalf, you know, trying to locate evidence that might have been missed. And please understand, we always state this: we are not cop bashers. We love police officers, investigators. They do what they have to do. It's just they're also human. They sometimes miss things. And it's not they're trying to do anything against you. It's just that it's good for you to have a fresh set of eyes that's coming in on a different day and looking at the scene and seeing what might have been missed. Like Don said, the new Ring cameras on people's doors with the person across the street, or a surveillance that might have been missed. We know the importance of this, and that's why having the only company that has a true boots on the ground, response, it's critical to the case.
Yeah.
Well, I think everyone is subject to this notion of confirmation bias. I'd love to hear Dr. Artwall's take on that. Police officers in our daily lives, no matter what we do, we have this tendency to get an idea about something, and then either consciously, mostly unconsciously, you look for those things that confirms what you thought it was, to the exclusion of other evidence sometimes or information that, had you looked at it objectively, may very well have completely changed your mind on a subject.
Yeah, that absolutely happened in the Maddox case, in which those officers and investigators, they just in their mind they had a dead body, a guy that said I did it. The quick answer is murder. And once you get that in your head as a policeman, especially younger policemen, because we run into that, a lot of younger, but some of the older guys who have been through these cases, they know to sit back and wait for all the evidence to come in and the facts, and try to seek additional facts.
Well, that was a great example, because the track was laid out so clearly from everybody's perspective that was investigating the case, that they even ignored eyewitnesses that had been identified. People they could have picked up the phone, and if they didn't get them the first time, you'd think you'd call back, right?
Correct.
You'd do something to be sure that wasn't important information that you had missed. And the Maddox case is exactly that, was critically important information. When our critical response guy was there and helped identify some of that video surveillance issue, and put people, and we hired experts to realize that the assumptions that law enforcement made about the sequence of events when these two discrete attacks were, they accused Steve Maddox of lying about it. We proved that was simply a function of them not knowing that the video systems weren't synchronized. So as soon as you figure that stuff out, it changes everything, absolutely everything.
Yeah, like when I look at these cases, just from, my perspective, I look at the importance of having a defense team. And when you think about the team, because everybody thinks about the lawyers, and absolutely, the quarterback is important. So the person that you have in that position, saying what the play is, looking at the defense, or the reverse, looking at your opponent, that person is key. But without those other players, because you can have the best lawyer ever, and if you don't have the investigators, the expert witnesses, if you don't have those other key players, you can still lose the game, no matter how good this person is. And that's the good thing about making sure we have the right, not looking for the cheapest guy, to be your expert, or not putting the money that you should put in on the investigative portion of it, because sometimes the lawyer can only go off of what's in front of them.
That's right, but you make a good point, though. Justin, what's another easy way for an innocent guy to get convicted? And that's having the wrong lawyer.
Correct.
Not necessarily a bad lawyer. They may be a good lawyer at what they usually do. They may even be a very skilled criminal defense lawyer without much experience in self-defense cases. We've talked all around how self-defense cases are unique. They're really different than any other criminal case that I've ever tried, and they require the insight to understand not just what happens at the scene and how you are able to put the jury in the mind of the accused, seeing how this thing unfolds as he or she did, knowing the things that he or she did, having the past that he or she did, knowing what he or she knew about the attacker. All of that stuff, whether you learn it through social media or on-the-ground investigation or prior contact between these individuals, all of that stuff becomes critically important in painting that picture for the jury, so that the jury can decide at the end of the day, were the actions reasonable? And they can only make a decision based upon what they have available from which to make that decision. So I pride myself on helping this company find lawyers to represent our members that have had actual hands-on self-defense case experience, that have been there, done that. I wouldn't want to be represented by somebody that was getting on-the-job training when my life was at stake.
Good
You're
point.
talking about attorneys. A question we get a lot. Can you explain why it's preferable to choose local attorneys? Why don't you just go fly around to every case we have? What is the benefit of hiring local attorneys to handle the cases with your support?
Sure. That's a very good question, because I believe strongly in that, and that's the model that I've encouraged these guys to adopt, and the focus of a lawyer getting involved in we'll talk about lethal self-defense shootings. There are less than lethal self-defense shootings, things where no one's hurt at all that are legitimately self-defense, that require the same kind of response, but just not the full court press that a lethal self-defense shooting. When you have a lawyer who works in the community, you have a lawyer who has a professional relationship typically with law enforcement. They may very well have had a case with the same investigating detective 6 months ago or 6 weeks ago or 6 years ago, and they can size each other up. The lawyer knows whether this is a guy who's a straight shooter or he's going to try to catch somebody at something. Likewise, the law enforcement would have a sense of understanding of who the lawyer is. Are they trustworthy? Are they well respected? Are they any good? A lot of cases are prosecuted in some way because of their anticipation of how the other side's going to deal with it. And if you have a rock-solid lawyer representing you, you're going to be treated with respect, maybe a little fear, because nobody wants to get caught with their thumb on the scale. They don't want to get caught lying. They don't want to have their reputations tarnished. So you get a fairer, more legitimate process. You may very well have had bond hearings on serious cases with the same judge that you get. So the judge has a sense of you and your professionalism, and whether when you say this person is a strong, stellar member of the community, that they can believe that it's not just some phony statement made to help get a guy out of jail. Likewise with the prosecutor, lethal cases, murder cases, anything where a gun is fired and someone's facing a lengthy prison sentence is going to draw the more senior prosecutors, sometimes career prosecutors. And if the prosecutor knows the lawyer on the other side because they've had cases, just because you've been adversarial with the other side in no way means they disrespect you or don't like you. In fact, a lot of times if it's a good head bashing, then you get more respect in the system, because people want those involved to play by the rules. Play hard, don't cheat, play by the rules.
Yeah.
So I know that's a long-winded way of saying that when you are representing somebody involved in a serious self-defense case, if you have a lawyer who understands all of those dynamics, including the local politics, I think that is an advantage.
Absolutely.
You may want to pair up with me. I'm happy to consult. I have consulted on cases just for strategy purposes and such. But I want someone on the ground who works there every day and is a well-respected member of the legal community.
Yeah. And then, Don, speaking of lawyers, we've had a case in which we've worked it from, just after the smoke to the end of a murder trial. But our most recent case with deadly force, we also worked a case in which we used our resources to get ahead of it. And prior to a determination being made by a DA or prosecutor, we actually used our services and teamed up with an attorney. Can you talk about the importance of gathering all those things and possibly getting ahead of cases? Because we've done that on a few now.
You're talking about that lethal
Yes.
incident not that long ago, actually. I think that case is a good example of the point that Justin was making about the value of having local competent counsel who knows the lay of the land. This was a lethal self-defense shooting. We hired a lawyer who met with the member and was there on site less than 24 hours. Now, the investigator had already been there. The member had been cooperative, as we've discussed. You know, I'll help you. I'll tell you what you need to know, but I'd really like to have counsel. And they respected that.
They do.
And that was the end of that. So our lawyer meets with him. Our lawyer happens to know the lead investigator from a case that they had worked not that long ago, and they had some immediate understanding and respect. And the assessment was, the detective is experienced, he's hard, but he's fair. If you don't jerk him around, he's going to be straight with you. So that's really, really valuable information. The prosecutor may not have been known immediately, but would within a few days, especially in a homicide. And then you can sort of assess how they handle these things. Do they get involved early? Do they sit back and wait? And do you have any concerns about how they might approach a certain kind of case? Well, that's a bit of background to a critical decision in this case, and that was law enforcement contacted the lawyer and said, we would like to talk with your client. We have a few questions to ask. Now, keep in mind, he hadn't really been debriefed fully at the beginning. We have a few questions we want to ask. We'd like to clear some things up. Is that okay? Can we make that decision? Most lawyers, certainly new lawyers or lawyers that haven't really worked extensively in this field, I think would have said, no, hell no, you're not talking to my client. He has a Fifth Amendment right not to say anything, and he's not. And they would have to respect that too. However, understanding that this was a critical stage of this case, that things had gone well so far, and all of those sort of inside information channels suggested they really weren't looking to jam them up. They really were probably looking, in fact, to get a few questions answered so they could make a charging decision. And the lawyer decided to do that. They actually, a few days later, did a little sit-down with the member. It was, of course, as all interviews should be presumed to be recorded, but it wasn't an interrogation. It was clear from the beginning what they had said was, in fact, true. I've got a few questions, want to clear a few things up, and that was the end of the case.
Yes.
You know, it didn't happen right that second, but the member successfully answered questions, appropriately answered questions, had the benefit of counsel. It was professional context and setting. The necessary information was then relayed to the prosecutor, who then ultimately made the decision, no charges. Now, talk about, you know, the yin and yang of life, right? Here's a guy, had he been charged, would have been looking at life in prison.
Correct.
Whether he ever got convicted is different, but the next 2 years of his life are like he's never seen before.
That's right.
Even at the end of the day, like Stephen Mannix, he's acquitted. But through the proper application of resources, and more importantly, the understanding of how those resources should be applied,
Correct.
the influence when you have it, and where to apply it, can make all the difference in the world, I think.
And I think this is a great example of what we have. A lot of the questions that we have, can I use my own attorney? Yes, you can use your own attorney, but they're going to have to be vetted by Don. And Don has a very good understanding of what a case needs specifically. All these shootings are going to be different. There's no two cases that are going to be the same, and they have to be looked at that from every decision through the case, including, you know, the decision to hire, you know, the proper attorney. So
absolutely, and then also, you know, with Don, not just his experience. We lean on that. He leans on ours for certain things in reference to investigators of decisions. But, you know, as far as working these types of cases, you know, his reputation is also very important to us, and the reputation that he establishes with the lawyers. You know, the last case that he was just making reference to, it was a holiday deadly force incident. Don was able to contact this attorney and get that person to work on a holiday, you know, so that's really, really big for us. And that leans on, you know, his professionalism and the relationships that he establishes. I mean, that's just so key for us in the way that we do our business, because we actually care, not saying no one else does, but we care about getting you that top-notch response and resources within the first 48 hours, because it's key to how the rest of the case is going to go. So just thanks again, Don, for being who you are.
I'm just, I'm glad to have connected up with you guys. I have liked what I saw from the very beginning. Now that I've been here, it's years now.
It's been
right?
a couple of years
Yeah,
now.
It's been a while.
He's the Don now.
I can continue to be impressed with the work you guys do, the commitment you have, the loyalty to the members.
That's right.
And that you say what you say, and then you do what you say.
Absolutely.
And I did want to compliment your nails.
Thank you, Don. Thank
Shiny
you, Don.
nails.
Yeah.
Hey, thanks for joining us again. We're going on about an hour, a little over. So, Don, thanks for coming
Thanks,
in.
Mike.
And
Thanks, Mike.
stay safe out there. Make some comments. Follow us on all our social media, YouTube, Instagram, Facebook. Put some comments on. Send us emails. You might get one of these tumblers.
Be safe.
Be safe.